All right, good evening, everyone. Welcome to another edition here of the Justice and Pieces guest speaker series. Today we have the president of the Ontario Paralegal Association. Very proud to have Mr. George Brown join us. Thank you, sir, for joining. And perhaps you can tell everyone here a bit about your background as well as the Ontario Paralegal Association.
I've been a paralegal for the last 24 years. I'm also the president of the Ontario Paralegal Association. I run a practice over in the Ronsonsville and Dundas area. I've been in the area for, maybe the last 10, 12 years. Just enjoying working as a paralegal, and I can add love it like the first day I started.
All right, so perhaps maybe you could tell us a bit about the Ontario Paralegal Association and the kinds of advocacy it does for paralegals.
Well, the Ontario Paralegal Association is, we consider it the voice of the paralegals in Ontario. We have a membership of around 1,800 members, but we speak for all 12,000 paralegals, whether or not they are our members or not. And I find it surprising at times that we're speaking for 10,000 people or so who are not our members, and that they permit us to do that. When there is an easy mechanism to join and be part of the conversation, so that they can help to guide us in the area that majority of the paralegals would want to go in. At this point, 1,800 people make the decision for 12,000. Doesn't look pretty good for a legal profession. The numbers are just skewed, but that's the way it's been. And so we make decisions for the entire profession. We have, over the past year and a half, have been negotiating with the Attorney General of Ontario. We've had opportunities to do that with respect to the criminal area of practice, or the scope of practice for criminal law. As some of you might be aware, the government implemented an amendment to the criminal code, which takes summary judgment processes from 6 months, 6 months less a day, to 2 years less a day. And that kind of moving the goalposts had the effect of taking all paralegals practicing that area out of criminal law. We were able to work in conjunction with the Law Society, the benchers, the paralegal benchers, that is, as well as the Attorney General, and receive an amendment to have paralegals continue working in criminal law and work on the new amendments, 2 years less a day. The effect of that was to amend the scope of practice of paralegals in criminal law, because some of the areas that they weren't able to do prior to the amendments, they were now able to do it. For example, hybrid matters. I don't practice in criminal law, so I won't get in depth into it, but hybrid matters was something that paralegals would have to back away from. We no longer do that. Also, paralegals were not allowed to practice in anything to do with assault with a deadly weapon. As a result of the amendments, we are now able to do that. So we celebrate this as an expansion of the scope of practice. We were also able to negotiate notary for paralegals. And so as you complete your studies and graduate, you're automatically a notary, and you're a notary for life. As long as you remain a paralegal, you are a notary. We have negotiated some amendments to the criminal code. The Landlord and Tenant or the Residential Tenancies Act, I should say. And we are still continuing to push for other amendments. One of those amendments, we wanted the Attorney General to change the words solicitor to licensee, which would then include paralegals in all of the different legislation that requires amendment. Just changing that one word, and it would solve a lot of the issues that some paralegals experience. So we continue.
स्पीकर है यार, आप दिमाग मत खराब करो, मेरे क्वेश्चन का तो कुछ रिप्लाई नहीं करते, आप जाओ यहाँ से.
So
Sorry about that. Someone was on mute there. Continue, please.
Yeah, we continue to work for paralegals and to expand the areas of practice. One of the things that I think is lacking is a public awareness campaign. Many years ago, when I started the Ontario Paralegal Network, we were trying to get paralegals to donate $50 each. At the time, we were 5,000 for us to start a public awareness campaign in which we would do social media advertisement, some TV advertisement, maybe a couple of billboards in certain strategic areas, maybe such as the 400, and also some radio ads. And we managed to do one commercial and didn't get any further than that. Lately, we've taken that commercial, and what we want to do is pass it around to every paralegal to post it in different social groups and anywhere on the internet, because where we are today, you don't need a radio station to run an ad. You can post that ad all over social media, and it accomplishes the same thing as running it on a radio station, just less expensive. So we did a survey. We sort of utilized a survey that was prepared by the federal government. And what the federal government said in the survey was that that 50% of Ontarians or Canadians will require legal services in any given year. I might be incorrect about the given year, and I'd be given 3 years. It's been a while. But we took that survey and we decided to apply it to Ontario. And at the time, Ontario the census figures was 12,000 residents. So we decided, okay, so based on the survey, there will be 6 million people. Now, we realized we had a lot of impurities in that 6 million after we cut it in half. But we don't have the money or the time to flush out those impurities. So we cut it in half, and then look at 3 million, take the 3 million and use the court data, filing data, to give us an idea of 3 million people, how many of those people are looking for legal services within the paralegal scope of practice. So we would have taken all of the filings at the landlord-tenant board over a year or 3 years, all of the filings in small claims court over a year or 2 years, all of the social justice filings, and so on, all within the scope of practice, criminal law. And we would then apply it to those numbers, to the population of 3 million. And when we looked at it, we realized that 80% of people looking for legal services were doing so within the paralegal scope of practice. And that tells us that our market share is huge, and that we have not actually claimed that market share. We are operating on 20 to maybe 30% at the max. So there is a much bigger market share. Another indicator of market share that is not being claimed by the paralegal profession. I realize we can't do family law, but if you look at family law, 60% of people are self-represented and cannot maneuver through the court. Therefore, that tells us again that there's a large body of people that could utilize paralegal services. And we believe that if we can capture that market share, there's no need, we won't have a situation where a paralegal comes out of school and can't find a job or can't set up their own bricks and mortar to provide their services. So we believe that is the biggest thing facing, I should say I believe that is the biggest obstacle facing the paralegal profession today, that we all run Google ads, not realizing that we're competing against each other for a word, paralegal, when we can take our own marketing initiative, come together and do a much bigger job in terms of making the Ontario public aware of who we are. The kind of campaign that I'm trying to spearhead is a kind of, for lack of a better word, I guess guerrilla warfare would be closer to it. And so what you do is you don't spend any money in the big markets like Toronto, Kitchener, Windsor, London, Oshawa, Kingston. You take that money and you go in the outskirts, the rural areas, and you plaster those rural areas. You're doing two things. You're helping the paralegal in that area, and at the same time, you're alarming any lawyers or other legal profession in the area to start calling back to Toronto to find out, why is the OPA, bombarding us in Thunder Bay? Well, that's exactly what we want, because when that message coming back to Ontario, that's free advertisement that we have woken up and that we're trying to take the market share. And once you leave Thunder Bay, you then go another rural area, or you run multiple rural areas. But if you start bombarding the rural areas, the word will come back into Toronto, because they're going to think we're crazy, but it's crazy science. So we think that I think it's the biggest thing lacking right now in the paralegal profession. Some of my colleagues spend so much of their time on social media fighting about, real silly things. I'm a businessman and I see the market share, it's wide open. Prior to the pandemic, my office, we go after market share. I think if we do it as a group, it's a bigger splash.
So how do you kind of get, as the president, try to get some consensus within the group or the board, or the directors or the organization at large, when there's all these competing interests to kind of get people to buy into that vision that you were just talking about?
Well, of our 1,800 members, we just recently had a poll because the word out there on social media was that somehow I wasn't forceful enough, or I'm not sure that I'm not the best president since sliced bread, and we put it to our members. 89% of our members believe that I'm going in the right direction, and they're behind me. 89%. If we took out the people who voted twice to try and defeat the motion, it would be in the 90%. So of our 1,800 members, everyone follows me. And I don't say it out of wanted to, raise my hand and beat my chest. I just think it makes sense that we come together and that we push the narrative about making this profession stronger, making this profession more professional in terms of how we view ourselves and how we want people to view us. And I think that's what has been lacking for a long time. We talk about dress code. I don't want to see any of our OPA members in court in a sweatpants or a sweat jacket. Believe me, we've seen that. There was a woman who came to court in a sweatsuit, and that's embarrassing. Dress for the part that you want, and who wants to hire someone dressed in a sweatsuit? I wouldn't. It tells me that person is struggling. So who wants to go to someone who's struggling? So the dress code, it's definitely a major factor. And the court decorum is another factor, knowing how to address the court, knowing how to function in the court. None of our paralegals need to go into court and be afraid of speaking to the bench. You're a licensee. You must speak to the bench, because if you cannot speak to the bench, then your clients don't need you. We also, in our CPD courses, we teach people how to draft claims. I get claims all the time, and had it not been for the fact that I'm being paid to respond to it, I would just throw it in the garbage. It's crazy. It's hell. The language, the grammar, the person who hired that person probably could have drafted a better claim. So if we want people to regard us as legal professionals, we have to stand and claim that that notoriety or that prize that we are professionals, and that's why people require our services. Access to justice means that we're going to take our clients into the court, but not just to sit there, to actually receive the justice that they go in to the court to receive. And if we don't know what we're doing and we don't know how to maneuver ourselves in the courthouse, the client is not going to get that result. So.
Now with that, I mean, there's a couple areas, namely immigration and family law, where there's been big issues coming up about potentially expanding the scope, and certainly with immigration relating to the change in the immigration consulting program going over to Queens there. Could you share maybe what thoughts or the OPA has with respect to family law and immigration law?
Well, the OPA has taken a look at the family law issue, and we feel that the family law issue is a roundtable discussion. I know some of my colleagues disagree with that, and they've gone into litigation. I just see the fact that one of the groups received its article of incorporation the same day that it commenced its action. So it never had a discussion. When we have to resort to lawsuit to get, what we're entitled to, I'm not sure it's the most productive way to do that. We've been able to negotiate with the Attorney General and receive some great benefits for the profession. I think that the immigration issue could have been negotiated as well. But what happens when you commence a lawsuit, everybody goes to their side. It's like a boxing ring. You need to go to your corner. So no one is talking anymore because they're in their corners. And the lawyers are now doing having the conversation. And that conversation is not about what's in the interest of each of the parties. as a sitting at a table, it's their individual interests. And so the parties who are trying to get something accomplished are not really at the table discussing it. Their lawyers doing it on behalf of their respective clients. We know that the lawyer profession sometimes doesn't think favorably of paralegal. So here we've given them this opportunity to kill this. And I'm sure that all of the other associations are packing their bags, ready to jump in this fight if they possibly can, or to give support. Sometimes it's best not to go this route, and I felt that we should have gone the negotiation route before we go this route. In addition to that, you have to know the position of the other side. And I don't think that we've actually learned what the Law Society's position is. And when you're negotiating with someone at a round table, you hope that it's going to be transparent enough that you're going to get what their position really is. And maybe after, getting what that position is, maybe we can, we could come to some semblance of an agreement that we both could walk away with. But now we're going to leave it to the lawyers, and then even more to another third party to make the decision. So, unfortunate.
Right. I mean, I had Mr. Robert Byrd on not too long ago and sort of shared the same thing about dialogue is better than just turning it over to litigation. But are you precluded there from still continuing the dialogue, even though, I mean, I don't know if you're a party to any of the litigation matters there, but.
The obstacle with the dialogue is it's in litigation. You can't talk about any of the positions because the parties in litigation are going to be warned not to have discussions with anyone. So that's what I meant about everybody's back to their corners. And if you imagine the boxer, it's his, he's getting his pep talk and, what he needs to do for the knockout punch. So that's where we are.
What about the family law services provider? I know there's a call to submissions for the end of the month from the Law Society. Is there a sort of a position from the OPA as a collective, or are they leaving it up to individual members to kind of write in and get support from those involved in family law?
The OPA has a position and will be submitting its position. And I believe that the Law Society and the lawyer profession are going to be surprised of our position. We believe that there are certain aspects of the proposal that we will decline because of the risk involved and the fact that certain proposal in the paper would put paralegal at a tremendous risk. We are going to decline anything that would require independent legal advice from a lawyer. We're not interested in that. We're also not interested in being supervised by a lawyer. So there is a few areas that may justify supervision by a lawyer. I think we will decline those because the scope is big enough to take those out and still leaves a good practice for paralegals. So.
And since I have a big audience here of paralegal students, so what advantages does the Ontario Paralegal Association have for student membership, and how can they become members of the OPA?
Now, as I said earlier on, the networking is the biggest advantage. to be in the midst of people who are actually in private practice, and to be able to have discussions with them while you're going through your theoretical training, and understanding how those theories that you're learning is applied. I remember the Ontario Paralegal Network did a CPD, and was at the York Library at the Mel Lastman Square. And what we did was we reserved half of the room for students who were actually going through the evidence portion of the curriculum. And the other half was like paralegal licensees. And I hate the word licensed paralegals because there are no unlicensed paralegals. And I'm not sure why all my colleagues just kind of bought into that. Sir, are you a licensed paralegal? I'll always say, I'm a paralegal licensee. There are no unlicensed paralegal, and we make it seem as though there's unlicensed paralegals. So we keep that little bit of a doubt still in even when we introduce ourselves. So in this particular CPD, you could see the lights going on and going off in the students' minds when they realize how what I've just learned about evidence, he's talking about how to apply it, and it completely makes sense, and now I get it. So the practical and the theory, kind of come together, and I think it speeds up the learning. I think it speeds up the understanding. We're advocating right now for students to be able to attend and appear on behalf of a paralegal licensee, to do uncontested motion, uncontested adjournments, so that they get the understanding of what it feels to go up in front of the court and say, Your Honor, my name is blah, blah, blah. I'm a student, and I'm a student with George Brown, and I'm here today to deal with this motion, which is consented to, and here is my consent, and just addressing the court. We think that's going to help our students. And we're waiting on the Law Society to give us the go on that.
Great. That seems like very excellent initiatives there, and other reasons for students for joining the Ontario Paralegal Association. Now, you mentioned your 89% sort of mandate there. I think any presidential candidate, there's an election going down in the U.S. as you know tonight, would love those numbers. So, looking back on your time as president, what are you most proud of? What are the accomplishments that you feel are the most significant, and are you going to continue to run again in the future?
No, I'm not going to continue to run. I think one term is enough. I think I'm going to do that walk that Pierre Trudeau did many years ago when he had to decide whether or not he's going to continue as a prime minister. And I think Nelson Mandela did a similar walk. I think we're in a situation where we don't need one person to clog the pipeline of new initiative, new ideas, and new initiatives coming forward. And I think one term as a president is good enough, and we get another president with new vision to continue where we left off. I don't think anyone would want to undo what we've done. I'm not sure it's undoable. And I'll be a supporter of that president and a supporter of the OPA.
Now, what advice would you have for that next president in taking on this role? What are the challenges and opportunities that they'll have as president?
I would say that I always want to tell the driver behind me that I'm in front of him, and the horn doesn't really make any sense because it's not going to do anything. I'm not going to do what you want me to do because you want me to speed up or drive. I'm in front of you. And if you want to, you go around me. So I would tell the other president, to block out the noise and implement your ideas. Look at what this profession needs and create the process for it to be a reality. I'm one of these believers that nothing is really chance, that it just takes initiative by people, and that when this whole Big Bang theory started, all of the possibilities that we could ever be happened at that moment, and we just have to sit down and process, and we can tap into ideas that are floating around, on how we can elevate ourselves and how we can make ourselves stand out. I'd love to see a paralegal profession where clients think maybe you should consult a paralegal, where that would be the normal, natural saying. Maybe you should consult a paralegal, and I think we can get to that point. I think we can reach that point because, as I've said before, we are the solution to access to justice. It cannot happen without us. So, in terms of what we've done, that I'm proud of, I'm proud of the notary. I think it was necessary. I think when you look at the big law firms, they're so concentrated on billable hours that taking the time to notarize a document is a waste of time for them. It's a loss of money. When you're billing $500 an hour, you don't have time to notarize a document. We have people scattered all over Ontario in rural areas, having to travel to major cities to go see a lawyer just to notarize a document. So one of the things we pushed for was remote notary, which is still on third reading and waiting to receive royal assent. So the way we propose third remote notary is that Ontario has a huge population of foreigners, and they utilize the internet more than most Canadians. And people who live in rural areas traveling to a major city to get notary is not a sign of the times. And that we can create a system in which, just like we're on Zoom now, the client sends in the document that they want to notarize prior to the Zoom meeting. During the Zoom meeting, the client then show the original of the document. I take a photograph of it during the Zoom meeting. I now witness the original, and now I can certify the copies, and I can put it in the mail back to that client. And that client didn't have to leave home. Or the client can instruct me to send that notarized copy to where it needs to go. And that's remote notary. And we think that's the way of the future. So.
You'd mentioned about tuning out the noise there for the next president. Perhaps we could sort of shift towards my students here who have a lot of those, the noise in terms of, you've mentioned social media, that you're seeing people asking questions and the responses they get are not very helpful, and it creates more of an issue. How can students learn from sort of these experiences there and not make those same mistakes? What advice do you have for them in terms of being able to tune out the noise and the naysayers and even the lawyers who think, hey, you're just a paralegal, what are you doing here? What can you offer for them and for newly licensed paralegals?
Well, the first thing I'll say is we're not just a paralegal, we are a paralegal. Secondly, once you complete your education and get your license, I think you should elevate yourself to understand you've made a major accomplishment. Law Society says you're competent to provide legal services in Ontario, and you have a potential client base of 12 million people. You need to think of the business aspect of this and not kind of like the need to convince some old-time paralegal out there who thinks, you know, he's God's gift to the world. There is nothing that I have done that any student, given application and time, cannot do. This is a learning based technology. It's the time that you put in, and it's your dedication, and it's your desire to be a professional. That is what builds your professionalism and your paralegal career. So do not let someone out there tell you you're not good enough for it, because I say to my son, you know, that you're created like a diamond, and anytime you start to let someone tell you that you're not, then you've made the first mistake. It's not that person, it's you. So you know what you've gone through to get to this point. You know how much sacrifice you've made. You probably have 1 or 2 degrees already, so you know who you are. So get out there and show us who you are, and don't let anyone tell you, you know, what you need to do and what you can't do. I think some of the resources that we're setting up at the OPA, that's going to help a lot of our students answer those questions that they might want to answer on social media. And we're setting up an internal conversation board where you don't have to go out there on social media and ask these questions. You can ask the professionals at the OPA, and they're going to direct you and give you links, because everything can be linked in the platform. So if you're asking me about negligent misrepresentation, I can link you to the research, I can link you to the case law, and you're on your way.
Now, on that point, actually, students have a mock trial coming up, and perhaps we can share some advocacy tips there in preparing for a hearing or a trial.
Preparing, the way I conduct myself in a case is I need to have an idea that I can win this case, whether or not I have to twist it, but there is a possibility I can win this case. There's a possibility that I can do something that's never done before, argued from a position that's never been argued before. And so the first thing you want to do when you take on a client is you want to do a little bit of research so that you have an idea where you're going. You're starting the roadmap. When you get to court, when you see people in court arguing a case, they've done a tremendous amount of work before they get to that point. That is where you shine. You have to know how to draft pleadings. That's the first step. Then you got to know what is evidence, and what evidence is good evidence, and what evidence is acceptable evidence to present in a case. You want to put, alert all your witnesses, send them letters, explain to them about the court process. It'll make a witness cling to you more if they feel that you're going to help them to help guide them through this process. And so we usually send out a letter advising them, about the process and about cross-examination, about examination in chief. If they're an expert witness, we want to send them all the details of what is expected of an expert witness. One of the things we also do is if we are the plaintiff and the other side is an unrepresented party, we sent out a letter to this person advising them that we don't represent their interests. They cannot trust us. We will lead them down the path because after that letter, we can do that. We will lead them down the path. and it's not tricking this person. We've already warned them. We only look out for the interests of our client, and we're there to win. So many times we get into court, and a party will say, well, Mr. Brown, told me this and told me that, and we will take out our letter. Your Honor, we sent him a self-represented party letter. Don't trust us. We're not trying to con him into doing anything. So if he did something after receiving this letter, he did this on his own, not by us. There is getting into trial is you want to prepare your client. The worst mistake is a client and the counsel not on the same page. By the time I get to court, I've gone through my document brief with my client. I know exactly how much time it's going to take my client through my document brief, subject to interruptions from the judge and maybe some objections from counsel. But if you know evidence, you're going to avoid those objections because you're not going to ask your client leading questions or violate any of the rules regarding examination in chief or cross-examination. So you get through, and once you get through your examination in chief, it's now your client's time to be cross-examined. You win a case, lose a case based on cross-examination. That's my feeling. If you don't know how to cross-examine a witness, you're not going to win. In addition to that, if you don't know the rules regarding cross-examination and how to protect your client, again, you're not going to win because you're going to allow someone to take advantage of your client. And so you need to know those rules and know how to apply them, when to apply them. Some people think that you shouldn't interrupt, make too many objections. That's nonsense. Make your objections anytime you need to make your objections, but be ready to argue your objections. So you don't want to make an objection and when the judge wants to hear why you're objecting, you can't explain. So you need to be prepared to do that. The other thing that we are doing is we've held some sessions on the new courtroom process, that everything is being done through electronic means, and that the trial advocacy has changed, and we need to adapt to the technology that we're using. And the reason I mentioned this is one of the things you don't want to do is when you're in front of the court and presenting your case, you are fiddling with things and shaking, because all of a sudden everybody starts looking at you and you're taken away from the case. You start to take the judge out of it because he's now looking at you and he's not hearing what you're saying. Yeah, exactly. So so we want people to take the center of the screen, stand still, not do the hand movements, because we do the hand movements when we're in the court and it looks fancy, but on Zoom, it is a crazy nightmare, So so we try to avoid the hand movements. We try to get people to do a little background. I know I don't have my background now, but set a background so it's not, not like an annoyance to the court or to other people, because we don't know how long this kind of litigation will last. For all you know, we may never return to a courtroom. This may be it. So we need to adjust and go for it. So as I was saying about the client, preparing the client for trial, there's nothing more beautiful when you and your client are on the same page. The examination in chief skills is that you cannot ask your client any direct questions. It has to be phrased as a question. And one way that you can know when you're asking a leading question, I'm sorry, I meant leading question. one way you can tell when you're asking a leading question, if the answer you're trying to elicit is a yes, then you're asking your client the leading question, because you're asking your client the answer that you want. And, you know, did you see the sky? Yes. Was it blue? Yes. Only cross-examination can do that. So when a litigator starts to do that in chief with his client, sooner or later, he's going to anger the judge, and the judge is going to, you know, rip a strip if that continues to happen, because the judge can deny all of that evidence because it wasn't a question. You led your own witness, which is forbidden. You would go around to get that answer. So what time of the day was it? Was it? Can you tell the court if it was what the sky looked like on that day? I'm actually doing a leading question, but I'm getting away with it because I threw in the judge and I kind of misdirect everyone that I'm asking a leading question. I'm making him talk to the judge. So it's like he's not talking to me. A lot of colleagues don't catch on to that. So I get away with that. Or when you view the sky, don't tell me what you think. Tell me what you observe. That's a leading question, but I'm getting away with it because I'm not asking him to tell me what he saw or what he thinks. I'm asking him to tell me, what did you observe when you do that? So it's totally his answer. I'm not asking for the answer. So there's these techniques that you use to get around leading your client and falling into a trap, and actually taking your clients through. So documents, I want to direct you to tab 1 of the plaintiff's document brief. And can you identify this document? Yes, I can. Well, what is this document? And then you're going to take him through the parts that are going to help your case. And so that document, we see sometimes people drafting claims and saying exhibit 1 or exhibit 2. It is not an exhibit. It cannot be an exhibit until it's entered by the judge. And so we have to be careful understanding that, because when we start referring to exhibits in our claim, they kind of know that we're new. So you want to try to avoid someone knowing that you're new, especially when you're an advocate for someone and you may be going up against someone who's been out there for a while. Don't give them the satisfaction that you're new. And the pleadings sometimes give it away because you're referring to exhibits instead of appendix. So, it's not difficult to develop these skills. You can go on YouTube and pick out videos that talk about the art of cross-examination. And for anyone who's going to practice, you've got to know the art of cross-examination. So.
Thank you so much for those tips. I think, Bryce, I don't know if you have a question there, or I thought you did, perhaps.
Not particularly. I did want to inquire, though. What you do sounds really interesting. Can somebody be a paralegal and just work for you guys and not really practice, or practice on the side kind of deal?
Yeah, you can do that. You can be in-house and not go in the courtroom, but that's denying yourself the fun.
Fair. No, just it's just, being part of an organization like that, not so much a member, but more on a higher level, like an actual employee, would be kind of fun.
Yeah, well,
I can see myself doing that.
I talked about the idea of paralegals not working alone and working in a group, in a team. To me, that's better. I did, 15 years working on my own. It's a tough haul. No one to bounce things, off. So you tend to research in the depths of research in order to get all of your knowledge and that you need for a particular situation. Whereas if you had maybe 2 or 3 other people, you could just bounce it off them and someone, oh yeah, I know that, this, maybe you should look at this.
Yeah, you're trying to make a new river versus just traveling the one that's already there, right? Yeah.
Exactly. Yeah.
Perfect. Thank you for that, Bryce, and thank you again, Mr. Brown, for joining us today. Perhaps you can end with any final words of wisdom for my paralegal students as they seek to gain into the profession and get out there and hopefully continue to be members of the OPA and continue to advocate for their clients.
Go for it. Don't let anyone stop you. You're unstoppable. It's such an amazing feeling to have someone walk into your office totally distraught, and 7 months later you're walking with them and they're so happy. You did your job for them. It's a privilege to serve people in that capacity. So thank you guys for having me. And hopefully I'll see some of you on the OPA front.
Great, perfect. Thank you again for joining us. And again, I think there's for those who are members, there's a meeting where you can sort of vocalize some of your thoughts and directions coming up, I think tomorrow, for all those interested. So thanks again, Mr. Brown, for joining us. Wish you all the best there.
Thank you. Bye now.
Thanks, Mr. Brown. Have a good day.
Thank you.
Thank you. Bye-bye.
Bye now.